beginning of knowledge is the discovery of something we do not understand. Frank Herbert. Ladies and gentlemen, principal, teachers and honored guests, it is with great enthusiasm that we gather here today for the lecture titled Insights on the Bare Act of CPC, How to Demystify the Technical Language of a Bare Act, organized by BBM, Kare College of Law under the aegis of Senior Advocate Manohar Usgaonkar, Center of Excellence. On behalf of BBM's Kare College of Law, I, Mariam George, a student of the institution, extend a warm and cordial welcome to everyone in attendance. We would also like to extend our warmest regards to the chief guest for the day, Hon'ble Advocate General of Goa, Senior Advocate Devidas Pangam, President of South Goa Advocate Association and member of the Board of Management of Vidya Vikas Mandal, Advocate Prasad Nayak, President of the Vidya Vikas Mandal, Mr. Nitin Kulkarni, Vice President of Vidya Vikas Mandal, Advocate Preetam Moraes, President of Alumni Association, Advocate Sanjit Desai, and President of the Parent Teacher Association, Advocate Arpit Arsekar. Respected Sir, Mr. Nitin Kulkarni is the President of the Vidya Vikas Mandal and is also the Chairman of the Governing Council of Kare College of Law. To formally welcome you all to this event, I'd like to invite respected Sir, Mr. Nitin Kulkarni to deliver the welcome address.
Good morning. Very eminent lawyer of the state and the Advocate General of Government of Goa, Advocate Devidas Pangam, very distinguished principal of Kare College of Law, teaching and non-teaching staff, students and friends. It's my proud privilege to welcome you all to this learning exercise. And today's topic is Insights on the Bare Act of CPC, and the concept behind that is demystifying the technical language of the Bare Acts. I am really grateful to Advocate Devidas Pangam for sparing his time. If at all, if anybody is busiest person in Goa, it's the Advocate General. And I have seen his schedules, but always he accommodates us. I am really grateful to you, sir, for making it today. And you guys are lucky to have me with you all for at least 1 hour. It's very important to learn from very eminent personalities like him. Demystifying the technical language of Bare Acts is a very important topic. All the Bare Acts are made with a purpose, objective, and they exist for many years. Over a period of society changes, the logic for which a particular act was enabled at that time may not be the same. There are many things happening in the government setup, political system, bureaucratic system, social system, global issues in the world. And in such a scenario, the technical language of the Bare Acts becomes very crucial. It changes, maybe the outlook changes. So hence, it's very important to understand any Bare Act with its core fundamentals. And I think it's a golden opportunity for you all to listen to Advocate General of the state today, because he has been also instrumental in many draftings of the state acts. But CPC today is going to be a big challenge. The new CPC which has come in post, it is going to be a very different thing. A lot of changes of last 20-25 years that has happened in the society have been incorporated. You all are lucky that you will get to hear. Imagine a batch which just passed a year back has to relearn all these things again. And I think I would request you all to give a good attention and try to derive maximum out of it. try to be research centric, try to focus on more these topics, try to learn from the precedents, and also see how you can also create more good precedents. And that is exactly the outlook when you try to understand the technical aspects of the language of the dialects. So I'm sure you will be richly benefited with the talk by our beloved Advocate General. I wish you all a good session and all the best. Thank you.
Thank you, sir. I request Mr. Nitin Kolikar to present a floral welcome to the chief guest, Hon'ble Senior Advocate Shri Devidas Pangam. Thank you, sir. I now request Assistant Professor Shirley Souza to graciously introduce our esteemed chief guest for today's event.
Respected Chief Guest, Senior Advocate Devidas Pangam, Advocate General of Goa, President of BPM and Chairman of the Governing Council, Mr. Nitin Kolikar, Officiating Principal Dr. Maria Baranti Simois, faculty members and our students. It is my privilege and honor to introduce to you a great personality and role model in our society. Honorable Chief Guest at today's function, at today's lecture, insights on the Bare Act of CPC, how to demystify the technical language of the Bare Act. Senior Advocate Devidas Pangam has been serving the state of Goa as the Advocate General since June 2019. His story is an inspiration to many. Born in a small village of Kare, near Sankeri town in a business family, Senior Advocate Pangam did his schooling in Progress High School, Sankeri and Shantadurga Higher Secondary School. He graduated from St. Xavier's College, Maksa and obtained his law degree from Usgaonkar College of Law, and joined the esteemed chambers of Advocate Ferdinand Rebello, who was then shortly elevated as the judge of the Bombay High Court. Subsequently, he joined the chambers of Justice Mahesh Sona, now the sitting judge of the Bombay High Court. Advocate Pangam practices in the Bombay High Court at Goa and is proficient in different fields of law such as constitutional law, income tax law, mining law, service law, and civil law. He has defended the constitutional validity of various legislations enacted by our legislature before the Bombay High Court, such as the Goa Green Cess Act, Goa Cess on Fluid Milk Control Act 2000, Goa Land Prohibition of Construction Act 1995, even in the highly contested Madhe dispute before the Honorable Supreme Court. He truly is a living example of kindness and humility. Besides law, Senior Advocate Pangam has keen interest in ancient world history, Indian mythology, and Goan culture. He is an ardent lover of Konkani and Marathi folklore and music. Welcome, sir.
The Civil Procedure Code is vital as it establishes comprehensive rules governing civil lawsuits, ensuring a structured and fair judicial process. It dictates how cases are initiated, managed, and resolved, promoting consistency across jurisdictions. The CPC safeguards the rights of parties involved by outlining procedures for pleadings, evidence presentations, and appeals, thereby enhancing access to justice. Senior Advocate Shri Devidas Pangam is a renowned expert in this field, and we are honored to have him here to enlighten us on this important topic. Sir, please take the stage and share your expertise and wisdom with us.
Good morning to all of you. I must apologize for having delayed coming here. In fact, it is not my mistake. I got confused. I once came here, went back to the city, and again I came back. So that's the reason for delay. Apologies for that. Nitin Kukwaider, I don't have to say much about him. You know him very well. He is one of the most prominent personalities in the state of Goa. In the field of education and in the field of industry, he has been a pioneer. We all cherish him and we all appreciate what he has done for the state and he is going to do for the state. The principal of your college, who happens to be an advocate, of course, the law college principal has to be an advocate. So I treat all of you as lawyers. So also the principal as the lawyer. She herself argued one matter recently in the court when it came to admission of your college. So she has not lost touch with the practice of law, although she is now in the academic field. Dear members of the faculty, surely of course I know her very well. We were together when we were practicing in Bombay Airport at Panji. Rest of the members of the faculty, my dear friends and all students, I am thankful to all of you for giving me this opportunity to come in front of you, because I think that one must again and again spend time with you. That is the way you can keep yourself very enthusiastic about the life. And you spend some time with the youth, that keeps you going. Otherwise, what happens is with your workload, with our quality of life, once you cross a particular age, it becomes difficult to keep enthusiasm. So one of the ways I think and I actually practice is that I spend some time with the youth so that it keeps me enthusiastic. But so far, so good. As far as today's topic is concerned, the topic itself is a mistake topic. It took me some time to really understand what is it like and what I am supposed to do. And with the lawyer's mind, I could, in my own way, actually decipher it, and that is how I am before you today. Now, it speaks about demystifying the language of the Bare Act. Now, if you take it as a language, it has a different connotation. If you speak or talk about it insofar as phrases which are there in CPC, it will take a different context. So let us start with the bare minimum thing as far as CPC is concerned. Then we will go to some part of words and phrases used in this particular book. As you know, this book is of 1908. We still follow it. The entire civil law and the civil cases are governed by this law. This contains the procedural law as well as certain substantive portion of the law. So, welcome to our advocates. Sorry, we missed you for some time. I mentioned your name earlier. So anyway, they are my dear friends. So coming back to the language of CPC. As I have told you, CPC contains basically procedural law, but there are certain substantive laws also. We may not go into that aspect of the matter in details today. Today we are concerned with particular language and the phraseology which is used in the CPC in the context of basically the young students who are studying this subject and who are going to become lawyers in future. Now, as you know, CPC is a procedure for deciding civil cases in the civil code. Please understand, these are the procedures prescribed for the civil code in civil cases. It has nothing to do with the procedures with the other tribunals or quasi-judicial authorities unless this procedure is extended specifically to those courts. So therefore, this is basically deciding our civil rights and the procedure thereof. Now, to start with, when we think about a civil case, we file a civil, when we file a civil case, it is called as a civil suit. In CPC, it is mentioned as civil suit. Now, you will ask me, what is this civil suit? A suit, as we understand, is what we wear. But this is not that type of suit. It is a lawsuit in the sense that it is a case that is filed and till it ends before the court. It is the entire thing that happens between the filing of the case up to the judgment before the civil court is called as a civil suit. To to say it in the most simplest manner. I really don't know, frankly speaking, why it is called as suit. It is a mystery for me, and I don't have really any answer to it. But in America, it is called as lawsuits. It is called as lawsuit. But rest of the English courts and our courts use the word suit. So basically, that is suit, and it starts from the filing of the plaint and culminates into the judgment. Now, what is plaint? Now, plaint is something which you file in the court, and that is how the case begins. Now, when you file a plaint, what is plaint? Plaint is not defined in CPC. Nowhere it is defined. But to tell you from the perspective of a common man and from the practical point of view, it is basically an application that is filed, making out what is the grievance of a party who wants to approach the court. And there are certain parameters and criteria which are laid down in CPC as to what this application should contain. And I will briefly tell you what it is. The first thing the plaint should have is a title. Now, what is that title? You are filing a case before a particular court. There are several courts. Now in Margao there are several courts. Civil Judge Senior Division, Civil Judge Junior Division. Then you have A court, B court, C court, D court. That is how you have all these courts. Now, first line should be, or what we do in the court is, we have to mention as to in which court we are filing this case, and that is how it starts with the phraseology. In the court of Civil Judge Senior Division at Margao. That is how it starts. Then you have to mention, the next thing you have to mention is case number or civil suit number so and so. Now, here also there are classifications. Like in our courts, the civil suits are divided into two situations or two classes. One is a special civil suit and the other is styled as regular civil suit. Now you will ask me what is the difference between these two. The suits are valued. I will come to it when it comes to the valuation of the suit. The suits are valued for the purpose of court fee and jurisdiction. Like as I told you, there are Civil Judge Junior Division and Civil Judge Senior Division. Now the jurisdiction of Civil Judge Junior Division is prescribed by way of an act called as Goa Civil Courts Act. So, when you value the suit, if the suit is valued below that particular threshold, then the case would lie before the junior division. If it is above that threshold, then it goes to the senior division. So, if the case is below a particular valuation, then it is called as a regular civil suit. If the case is above a particular valuation, it is called as special civil suit. That is how you have to describe. I will tell you how the suits are to be valued later on. But presently, just remember that you have to classify it as a special civil suit or a regular civil suit. Then comes the description of parties. Now, whoever files the case is or are called as plaintiff or plaintiffs. That is somebody who files a complaint to the, I am using this language, complaint, in a common parlance, but you should not use it. In the legal parlance, the correct word is the plaintiffs. So, whoever has the grievance and whoever wants some relief from the court is described as a plaintiff. Now, plaintiff is the one who is aggrieved by some action of the other side and his rights have been violated, therefore he is going to the court. So, he is described as a plaintiff. Now, there may be more than one plaintiff also. Supposing that my brothers, my sisters and my spouse and spouses of my siblings, if they are the owners of one property, all of us will have to be joined as plaintiffs. And somebody else who is interfering with our right will be described as a defendant. So, as far as plaintiffs are concerned, plaintiffs are going to be those who have a right and whose rights have been affected and who are seeking relief from the court. So, remember that these are three ingredients of a person to be a plaintiff. One is a person who has a right. Second is a person whose rights are affected by the other side, and the third is a person who can claim relief from the court. These are all called as plaintiffs. So plaintiffs can be only people who are falling within these three brackets. Now, as far as defendants are concerned, it is said that the plaintiff is called as dominus litis. The meaning thereof is the plaintiffs have a right to choose their opponents. It is their right to decide I am as to against whom I am claiming my right, against whom I am seeking relief, and against whom I will agitate my rights. But there is an exception. The court sometimes may direct the plaintiff that you have not joined the correct party, or you have missed out some party to be joined as a party because his rights may be affected by the decision in this suit. Therefore, I direct you to join somebody as a party. The third situation is the third party may think that see this case is going on in which my rights are going to be decided, although I am not a party to this proceeding. He can file an application before the court and say that please join me as a party. This is a situation that may arise, but normally the plaintiff is a dominus litis. He is supposed to decide who are going to be his opponents. This is how the parties are arrayed in a plaintiff. Then comes as to description of your suit. You are supposed to describe as to what is the nature of suit. Like for example, you have to mention just below the cause title. Now what I have mentioned to you as a plaintiff versus defendant, it is called as cause title. Then comes the description of the suit. Now the suit may be for several reliefs or on several grounds. The suit may be for recovery of money. So then you have to mention it as suit for recovery of money. Sometimes the suit is for injunction. Supposing that this is my property, some third party is interfering with my property, then in such a situation, you file a suit for injunction that the third party should not interfere with the proprietary rights of mine. So on and so forth, there are many suits, many types of suits which are there in CPC. But it depends on what type of suit you are filing, you have to describe it. Then comes the body of the claim. Now this is very, very crucial. Now what are you supposed to have in this body of the petition? Firstly, if you are claiming a right to your property and in respect of your property, the most important thing is you have to describe your property. Your property should be described either by way of survey numbers or by way of boundaries or by way of the nomenclature of the property. Many times properties are named, in survey records names are named. So you have to properly identify your property in that particular claim. Then you have to describe what are the rights of the plaintiff in respect of that property. If it is a suit for regarding the property, you have to say that this is my right. This is how I have the right, and my rights are flown in this manner through so and so X, Y, Z, my father, my grandfather, so on and so forth. You have to describe that. Thereafter, you have to describe a cause of action. Now, what is that cause of action? Now, this is very, very important. Now, cause of action is also not described or defined in the CPC. Basically, what is defined by the Supreme Court as cause of action means a bundle of facts. This is the phraseology used by the Supreme Court. It is called as bundle of facts which entitles a party to claim a relief in a particular case. Now, what is this bundle of facts? Bundle of facts is first that how do you say that you have a right? Therefore, you have to first say your status. Like for example, if you are claiming some right based on the Constitution of India or as a fundamental right, you have to first state that you are a citizen of India. This is what you are supposed to say. Unless you are a citizen of India, you don't have a fundamental rights which are particularly mentioned in the Constitution. Supposing that you are claiming right as to a property through your father, then you have to say that this property which I have described is owned by my father, or rather was owned by my father. This is his title document by virtue of which he owns this property. And after his demise, either by operation of law, that means merely there is a death of your parent, you give that property devolves upon you, or maybe by virtue of a will, or by virtue of a document called as deed of family settlement, or a succession deed. Whatever it is, you have to describe that this is how I have got my property from my father. This is what is one facet of the bundle of facts which I am telling. Then comes the next crucial thing as to what has happened to your right? In the sense that how somebody is interfering, that is how the defendants are interfering with your property. Like it may be so that your siblings are trying to alienate the property without your consent. So you have to describe that my sibling so and so, although he is the owner of the property, but he cannot alienate the property, or he cannot carry out any construction over the property without my consent. That is how my rights are affected. That is what you have to describe. Then comes a situation where you have to say that exactly as to what are the defendants doing. You have to say whether the defendants are trying to sell the property, or whether they are trying to construct anything in the property, or they have allowed somebody to do some activities there, so on and so forth. So this is what you have to describe. Then you have to say, after describing this, as to what is that you are seeking from the court. Are you seeking an order that you should not alienate the property? Are you seeking an order from the court that you should not carry out any construction in the property? Are you seeking any relief to say that you should not destroy the property? That is what you have to set out in the claim. This is what is a cause of action, and this is what these are all supposed to be the bundle of facts. Now, this is after reading all this, you have read everything as far as your case is concerned. But thereafter, 2 or 3 things are important to be set out in the claim. First thing you have to set out is, as I told you earlier, you have to value the suit. It is very, very important that you value the suit, and this valuation has to be on 2 counts. One is you have to value the suit for the purpose of payment of court fees, and you have to value the suit for the purpose of jurisdiction of the court. As I told you, the civil judges have unlimited jurisdiction. Civil judge senior division. Civil judge junior divisions will have a threshold of jurisdiction. So when you value the suit, you have to, now you will ask me, how are you going to value the suit? There is a law in that regard that is called as Suit Valuation Act. Now in that act, it is prescribed as to what suits are to be valued in what manner and to what extent. If you go to that book, it is mentioned that if you are seeking a declaration that you are owner, or you are seeking a declaration of your status, then the suit will be valued at X. If you are seeking a recovery of money, basically it will be ad valorem. What is the meaning of ad valorem is how much money you are asking for from the other side. Like for example, you are seeking to recover 1 crore of rupees from the other side. Then accordingly, there is in the stamp in the court fee set, there is a table in which you will find that if the suit is valued at 1 crore for recovery of money, X amount will be the court fee that will be paid. So accordingly, you have to value the suit. Now the details, when you come in practice, you will come to know how it has to be actually done. Once you mention the valuation of the suit, the next thing you have to say, and that is very, very important, you have to say that when has the cause of action arisen. Now what does this mean? This means that you have to say, as I gave an illustration of a case where a co-owner or a brother is filing a case against another brother. You have to set out that on so and so date, my brother went to the property, carried out construction without my consent. So that is the date when the cause of action arose in your favor. And then therefore, if you say that, why this is important? This is important for the purpose of limitation. The suit normally for an injunction has to be filed within 3 years from the date of cause of action. So you have to set out in the claim that the cause of action is arisen on so and so date, and therefore my suit is within limitation. That is why this aspect is very, very important. Then one statement you have to make further in the claim is whether there is a caveat filed by the other side. You know, I will tell you in short what is caveat. Caveat is an application filed by a party who expects that somebody else will file a case against me in the court, and he may snatch an ex parte order against me. Ex parte means without hearing me, the court may grant some ex parte temporary order in his favor. So therefore, a party, everybody has a right to go to the court and file this caveat application to tell the court saying that if anybody or X person files a case against me, please issue me a notice first hear me and thereafter consider passing of an order. This is what is caveat. So you have to make that statement in the plain that we have not received any notice of caveat from the defendants. That statement you have to make. Then you have to thereafter say that I am paying a court fee of X for the release which I have sought. I have told you there is a court fees act in which it is prescribed what court fees payable in respect of what type of suits. So you have to make that statement in the plain. And thereafter comes the crucial part of it are the prayers. You have to set up what prayers you are asking for. You may seek a relief that in the form of declaration that you should be declared as a owner of this property. Then you can claim a second prayer that injunction should be granted against the other side that he should not interfere with the property, and so on and so forth. So this is basically a plain. Then comes the written statement. Now what is written statement? When the notice is issued to the other side is supposed to file a reply to it, which in the legal parlance is called as written statement in CPC. Now, written statement basically, you have to remember 2 or 3 things. You have to deal with each and every paragraph of the claim. Either you have to deny it or admit it. This is what you have to do, because if you don't deny, it will amount to admission. So everything that is stated in the claim has to be dealt with in your written statement. And the denial has to be very, very specific and clear. A vague denial will amount to an admission. If in the plain it is said that I am the owner of this property, the reply should be that I do not admit that you are the owner of this property, or that you should say I deny that you are the owner of the property. But you cannot say that I do not know about it. If you say I do not know about it, or sometimes some lawyers say that the contents of para 1 are denied for want of knowledge, or this is not a denial at all. If you say that you don't know anything of paragraph 1, then that means you are not denying it. How do a person deny something which is not known to him? If I have to deny that somebody is the owner of the property, I should have a knowledge of it. If I don't deny it, then it doesn't amount to a denial. If I say that I don't have the knowledge, many times, and there is a direct judgment of the Supreme Court on this point, that if you say that you don't have a knowledge of a particular fact, and then you just deny it simplicity, it is not a denial. This is what you have to remember. You have to specifically say that he is not the owner of the property, or you have to say that I do not admit. There are 2 things. There is a vast difference by saying that I do. It is denied for want of knowledge, and by saying that I do not admit. So this is very, very crucial thing when it comes to written statement. Now, there are 2 or 3 things which you remember when it comes to written statement as well as the plain. Now, the law is that in this both the documents you should plead the facts only. You don't have to plead the law, and you don't have to give certain details which are required to be given in the written statement. You can simply say deny it. But there are 3 or 4 things when you have to be very, very clear, where you may have to plead evidence also. Like for example, when you say a misrepresentation, when you say there is a fraud, when you say that I have been cheated, you have to give the clear facts. In the sense that you did not simply just say that I have been cheated, that somebody has played a fraud on me. You have to establish by, or rather you have to plead how fraud was played on you. Like for example, supposing that you say that somebody took some money from me and with a promise to say that he will give me some goods or he will supply me goods. Now this statement is not sufficient. When this type of pleadings are to be made, you have to be very, very careful. You have to now state that X person came to me on so and so date. On so and so date, he told me that he will supply X amount of particular goods. That time he held out to me that he will give this or supply these goods to me by particular date. Thereafter, on the promise that was held out to me, I gave him a check of rupees so and so, or I gave him a cash of rupees so and so date, and you have to say the date on which he was supposed to give me those goods was X. So you have to state all this details, because when it comes to cheating, fraud, misrepresentation, the CPC requires you to make specific pleadings. In fact, you have to lead evidence also. You can say that by check number so and so I had given this money. Then so and so was a witness to it. All these facts have to be stated when it comes to these 3-4 things. There, the CPC is very clear that these facts like fraud, misleading, etc., have to be separately pleaded and specifically. So that is what you should remember about plain and written statement. Now, apart from plain and written statement, what is there is called as, there is one aspect called as counterclaim and set off. Now, what is this counterclaim and set off? Many times what happens is in a business transaction or any type of transaction, the defendants also have certain rights against the plaintiff. Like for example, in a case where plaintiff seeks to recover 1 lakh of rupees from the defendant, but in that very same transaction, the defendant may say that this 1 lakh of rupees I am disputing, but apart from this 1 lakh, the plaintiff is liable to pay me 2 lakhs of rupees. So this is called as counterclaim. So he can file a counterclaim and say that I am entitled to recover 2 lakhs from the plaintiff. This is called as counterclaim. Now what is set off? Now set off is slightly different. Set off is like in the same illustration, 1 lakh of rupees is supposed to be recovered from the defendant. But the defendant comes to the court and says that no, if you really see, he is supposed to pay me another 50,000 of rupees, which have to be deducted from this 1 lakh of rupees. So it has to be set off. So it has to be adjusted. This is called as set off. Or you may say that in respect of another transaction, he is liable to pay me 1 lakh of rupees. So therefore, it is equal now. I am not liable to pay. That is called as set off. So these are when we speak about pleadings, we have plain, written statement, counterclaim, and set off. These are 4 things which are prescribed in CPC. This is all about pleadings. The next stage in the court is of framing of issues. Now, framing of issues is very simple. If the plaintiff has said X and the defendant has denied it, the issue arises. Like simplicity telling you, as far as our own illustration is concerned, if the plaintiff says that I am the owner of this property, and the defendant says that no, I deny that you are the owner of the property, the issue arises as to whether the plaintiff proves that he is the owner of the suit property. This is how the issues are framed. And similarly, the burden is cast. Like defendant says that your suit is barred by limitation. So then the issue would arise whether the suit is within limitation. So on and so forth, the issues are framed. Then comes the stage of evidence. Evidence, I will briefly tell you how it goes on. First, the plaintiff files the affidavit in evidence. Thereafter, the defendant cross-examines it. And then if it is necessary, there is re-examination. So this is the stage of evidence. Now in the evidence, parties produce their documents. Original documents are produced on record. The court takes it on record. And thereafter, after the evidence is completed, the defendant is entitled to read evidence. Thereafter, the judgment. So that is how the frame of the suit is. Suit starts with the filing of the claim, ends with the judgment by the court. So this is how the overall picture is as far as suit is concerned. Now, the language of our today's topic is demystifying the language of CPC. Now let us come to this particular aspect of the matter. It is so vast that it is not possible to talk about it. But I will deal with only 2 or 3 topics today, which may be sounding very mystifying. So 2 or 3 topics I will just talk about. The first topic on this aspect I can talk about a principle or a doctrine called as res judicata. Now what is this res judicata? It's a Latin word which is there in our legal system. What is it now? Res judicata is covered by CPC, and what does it say? It says like this: an issue that is decided finally by the competent court of law in an earlier case between the same parties will never be tried in a new case that is filed between the same parties or the people claiming through the same parties. That is the meaning of it. Now what does this mean? Supposing that there was a case that was filed between me and A. In that, there was an issue framed as to whether I am the owner of X property. Now, that issue has been answered against me up to the level of the Supreme Court. It has been held that I am not the owner of this property. Now, if after 10 years, some other case is filed by somebody against me, and in that case, if I raise a plea that I am the owner of that property, then that issue will be hit by doctrine of res judicata. That means the competent court of law has finally decided that I am not the owner of the property. But remember that it has to be between the same parties and parties claiming through the same parties. Like supposing that my right vis-a-vis A is decided by the Supreme Court, but in a different case, somebody else who is claiming a different title or a different head altogether claims the same property against me, it will be not hit as far as doctrine of res judicata is concerned. In that case, I can still plead that I am the owner of the property. But as far as the other person is concerned against whom that issue has attained finality, I cannot raise this claim. It is important to note that there are 2 or 3 ingredients of res judicata. One is that the issue should be there and substantially decided in the earlier proceedings. Secondly, it should be between the same 2 parties or parties claiming through the same person. This is the second thing. And the third thing, which is very, very important, is that it has to be decided by a competent court of law. If it was not decided by the competent court of law, then this doctrine of res judicata doesn't apply. Supposing the case had to be decided, let us say the case had to be decided by the Mamletdar, and the Mamletdar has decided this issue, like for example under the tenancy, tenancy issues can be decided only by Mamletdar. If the Mamletdar has decided my right of tenancy, that is a court of competent jurisdiction. But supposing that a civil court were to decide that I am not the agricultural tenant of this plot, then this issue will not become res judicata, because that judgment is without jurisdiction. So 3 things, most important thing is the issue should be same. Secondly, it should be between the same parties, and the third thing is it should be by a competent court of law. If it is decided by an incompetent court of law, you can always raise a plea and say that no, it was without jurisdiction, so it is not hit by res judicata. So this is all about res judicata. The next topic I can touch upon is section 10 of CPC, that is sub judice. There is one doctrine called sub judice. Now what is sub judice? Sub judice is very simple thing. Supposing that there is a case that is filed by me against A. Now in that case what I am saying is that I claim to be the owner of that property, the other side is interfering with my property. And in the same property, I say that I am the owner of the X property. Now that case is going on. While that case is going on, what happens is the tenant of Y files case against me in respect of the same property. While this case is going on, a second case is filed by the tenant of X against me in respect of the same property. Now what is to be done? Can this case simultaneously go? No, they cannot. Then the doctrine of sub judice would come in picture. The law is, if the same issues are there in 2 cases, and identical situations or identical problems have arisen between the same parties or parties claiming through the same title, then the law is the subsequent suit has to be stayed. The proceedings in the subsequent suit are liable to be stayed till the first suit is decided. So under section 10, the court will say that let us first decide the first suit, and it sounds so logical also. If I have filed the case against X tenants who claims through X, the tenant doesn't have independent right. His right is through X. So his right will depend on the right of X. So the case between X and me, which is filed first in point of time, will have to be decided first, and the next case that is filed by the tenant of the X will have to be stayed. That is called as doctrine of res judicata. These are two things which are there in CPC. There are several other doctrines which are there in CPC. One is a doctrine or a principle of jus terti. What is this jus terti? Jus terti is when a case is filed by X against Y. Now X says that I am the owner of the property. I had given this property to the tenant on lease for 10 years. 10 years have now expired. And after expiry of 10 years, the tenant does not have the right and he has to be thrown out. He is not able to vacate, the court has to pass a decree of eviction. Now what happens in the written statement, the tenant comes and tells the court that, see, it is true that I have executed a lease with A. I have acquired this property on tenancy from A. But A is not the actual owner of the property. It is B who is the owner of the property. Therefore, A doesn't have the right to file the suit. He has no right to file this eviction suit against me. He cannot evict. Now, in that situation, the doctrine of jus terti will come. Now, literally, in literal sense, what jus terti means is that you are setting up a title in the third person. So, this is a law of estoppel. The tenant will not able to argue before the court and say that the one who has put me in possession, the one who has executed the lease deed in my favor, has no right to the property, and it is somebody else, the third party, who has the right to the property. The court will forbid him from doing it. The court will say, no, I will not hear you on that. You have executed a lease deed with this man, he has put you in possession of this property, you can't be permitted to say that somebody else is the owner of the property. This is called as the doctrine of jus terti. So there are several principles under CPC which we can discuss, but I think we have a paucity of time. Therefore, I have restricted it to 2 or 3. I'm sorry I had to go in details about the frame of the suit by telling you what is suit and it starts from what stage and it ends with what stage. It took me a long time to possibly say that. But anyway, the topic is so vast that it is not possible. I think even what I have said is not even a drop from the ocean. So therefore, I think I will stop at this time. I think it's already 45 minutes. So thank you so much. If anybody has any question, if you can ask me, I will sit and answer.
If there are any queries or clarifications of the topic, please ask them now. Does anyone have any questions?
Yeah, it was a very wonderful listening to you as always and very enlightening. I have a question. Like for example, there is a doctrine of promissory estoppel, and while the doctrine of promissory estoppel is a very important doctrine, it says that there should. I mean, it's like to build up a rule of law system to hold everything that is done in good faith by the government. Government should be able to deliver. Government should not go back. But there are of late statements like there won't lie any estoppel against the government if it is done in public interest. What do you feel about it? How do you feel like to do
The doctrine of promissory estoppel basically comes under the administrative law. As you will come in the profession, there is a branch of law called as administrative law, which we practice every day in the High Court. All that is being argued in the High Court is based on administrative law system. So basically what it says is that based on the representations held out by A party, if B has changed his position to his detriment, A will not be permitted to deny or to fulfill the promise that is held out. That is what is called as promissory estoppel. Now same thing would apply to the government also. If the government has promised something to the public, the law requires that that promise should be honored. Now there are two doctrines in administrative law which go side by side. One is doctrine of promissory estoppel and other is doctrine of legitimate expectation. They go side by side. Now there are exceptions to this doctrine. The main doctrine is the main exception to this doctrine is one thing is that that promise should not be contrary to any law. If the promise that is held out is contrary to law, then that promise cannot be enforced in law. This is the first thing. Second thing is the promise simpliciter is not sufficient. You require a further step to be taken for the purpose of enforcing this doctrine, and that step is that you have to change your position to your detriment. Then only this doctrine of promissory estoppel would apply. Now, what does this mean now? How do we change your position to your detriment? Simpliciter saying that supposing that the government tells you that you please set up an industry here, I will provide you X, Y, Z facilities. Based on that promise, if you set up an industry, that means you have changed your position to your detriment. The government cannot say that I am not going to supply electricity line. You please take care of your electricity. So this is what it is. Means you should put yourself in such a position that it becomes irreversible. That is called as what you say is that you put yourself to your detriment. Now, as far as government going back on the promise is concerned, there are some exceptions on which the government can go back. And one principle that is developed by the Supreme Court is this, that in the ultimate public interest, extreme public interest, the government can go back. And one illustration which I can give now is this. Before the COVID, the government is to grant some concession to its employees. Like for example, there was what is called as house building allowance. And what used to happen there was that if a government servant was supposed to buy a property, or house property, residential property, if he was to take a loan from the bank, the government would pay the entire interest, which was over and about 2% interest. Supposing that the bank interest is 14%, the government would pay 12% of the interest. The party was allowed to pay only 2% of the interest. So this was a facility that was provided to the government employees. What happened was, suddenly we were struck with COVID. There was no finances with the government, absolutely nothing, because every tax payment stopped, revenue stopped. So government said that from today onwards we are not going to pay. Now, actually it is a promise that is held out. Based on this promise, the government servants have taken loans of 50 lakhs, 40 lakhs, but suddenly it stopped. But now that is, you can't help it, because this is such a this problem was of such a nature that it was impossible for the government to honor this promise. Therefore, of course, this case is pending in the High Court, but they will specifically refuse a stay on this. No interim relief was granted, and that is how we have defended it in the court of law, saying that this is a situation where the promise that was held out was not possible to be performed, and in the public interest, we are going back on our statement.
Thank you, sir. Thank you. Students, why are you not asking questions? You should be inquisitive. Yes, please. Yeah.
Dr. Sir. So you said we have to value the suit, and when it comes to valuing the suit, the jurisdiction of the court comes into the picture. What happens when there is multiple jurisdiction coming into the picture? How does CPC handle it?
I didn't get you multiple jurisdiction means what?
Like when there are multiple jurisdiction involved in the case, like not only one jurisdiction but multiple jurisdiction. How does CPC handle this?
See, there are two types of jurisdiction. As we said, I told you there is pecuniary jurisdiction. If it is a pecuniary jurisdiction, like for example, you have made 3 prayers. Okay, one prayer has to go to the junior division, other prayer may have to be filed before the senior division, the third prayer may have to be filed before the district court. If in that situation you have to go to the highest court, so you have to file a case in the district court. This is about now pecuniary jurisdiction, purely pecuniary jurisdiction. But if it is a subject jurisdiction, you have no choice. Suppose that you are claiming a tenancy, agricultural tenancy against somebody else, that X person is my landlord, I am filing a case against him, and you have to go to the Mamledar, you don't have a choice. But supposing that you want some damages against your landlord, or having, let us say, he has interfered with your tenancy, he has destroyed your plantation. Now, there are certain reliefs which the Mamledar can grant, but possibly Mamledar won't be able to grant you damages. For that, you may have to file a civil suit. So, therefore, this subject matter jurisdiction, whenever these multiple issues arise, you have to go to the relevant courts. You can't go to the same. Pecuniary jurisdiction, you can go to the highest court. Thank you.
Yeah. Prepare your questions. You have enough time now.
Sir, I wanted to know why the courts doesn't have limitations for all the cases. Because some cases go on even for 50 years.
See, it is not as if that there are no limitations prescribed for disposal of cases. There are certain laws which provide that the case should be over within so much of time, but they are not held to be mandatory. Reason being, it is not practical. Now, our problem in India is that one judge in a year can decide X number of cases. That is the capacity of one judge. But he has not only twice or three times, he has cases 10 times of his capacity. So this is a problem, nothing to do with the law, nothing to do with the system. It has a problem with the population. We are not able to cope up with the population. And number of population will decide the number of cases. So you can't help it. People are trying to solve and finish the cases at the earliest. Government is making effort, courts are making efforts, fast track courts are established, but we are not able to cope up. The only solution to this is that our population should come down, consequently the cases will come down, and that is the only solution. There is no other way. Everybody has tried it. And another thing which is very, very important is that we may not be able to completely get rid of this menace, but the most important thing that should happen is if we appoint competent judges, we can get some relief. At least 25% of the cases will be disposed of more than what is being disposed of. Competent judges can dispose of the cases very fast. They have a control over their court. They can finish the cases fast because if somebody is going just like that, go on going with the case, that judge is competent to stop it there and there itself and say that no, I am not going to allow this case to get derailed like this for years and years. And that is one of the ways to reduce it. But still it will not get completely wiped out. The only solution is let us reduce our population, our problems will be solved. Thank you.
Sir, yes, regarding about actually administrative law as well as constitutional law. My question regarding the inquiry which is conducted by the police department. Suppose the case was going on in the court, and the case was finalized, particularly whatever the judgment has been passed, and in the judgment, it is said that the inquiry has to be conducted by so authority. But police were not the part of the authority, and police are conducting again the inquiry, wherein the police department has already given the report saying that the interim report may be considered as a final report. And if the police department is again conducting after a prolonged year of time, whether it comes under this res judicata.
Now, first of all, you should remember, doctrine of res judicata applies only to civil cases. CPC is not applicable to police. It is CRPC that applies to the police. So that doctrine is not there. But there is another principle there that is contained in the Constitution itself, and it is there in CRPC also, that nobody shall be punished twice for the same offence. that principle, that is called a double jeopardy, that principle would apply. But you have to come out with a concrete case where this has happened. Otherwise, it is not possible to vex the person criminally twice for the same offense. Thank you.
Last two questions.
Good afternoon, sir.
Good afternoon.
Yeah, we were talking about this section 10, substitutes that can be done to prevent this duplicity of cases in the same court.
Your question, I didn't get your question.
We were talking about
You can hold the mic upright.
you were talking about section 10,
Yes.
the sub-judice part of it.
Yes.
Regarding publicity of the case pertaining to the same case in the same court, and any mechanism that can be put in place to prevent such publicity.
Yes, that is what normally what happens. It happens in the court of law that there is one earlier filed case, there is a subsequently filed case. So the parties file an application before the court under section 10 for stay of their subsequent suit or proceedings, and the courts normally stay it. That happens. It happens regularly.
Thank you, sir.
Good afternoon.
Good afternoon.
I want to check on one is the procedural aspects that adjournments as well as condonation of delay. These are actually procedural aspects, but we see them being in a way misused in court. So, what are your thoughts about it?
There are two things you have said. One is about adjournment, and other is about the condonation. Now, condonation is you should know the basic principle of, behind condonation. What does the law of limitation do? Law of limitation do not destroy your right. It only bars you from going to the court or to a forum. That's all. Your right is always there. Now, what the Supreme Court has said about this is that as far as possible, the court should try and decide the cases on merits. This is one thing. Second thing is, what they say is people normally do not delay their cases, or rather do not delay filing of the cases, because ultimately if they delay, they are the sufferers. So it's very difficult to say that they have done it purposely. See, if I don't file a case in time, who is going to suffer? It is me who is going to suffer. So the courts think, basically they think that this technicality of limitation, if some sort of the reasons are shown as to why he could not approach the court in a time, then the courts are liberal in condonation of delay. So this is one aspect of the matter. As far as adjournments are concerned, there are two ways of looking at it. Sometimes the adjournments are genuine. In fact, believe me, we are advocates. Sometimes adjournments are really genuine because you can't help it. If the party has not given you the document in time, and I am supposed to present the document to the court today, what do I do? If the court shuts my case today saying that your time to file the document is over, then what happens? You are completely blocking access of justice to this person. You are denying him right at least to put forth this case. This is one. Second thing is, now we have so many cases which are going on. One lawyer will have cases with 10 courts. So these are practical difficulties. The third thing is what happens in so far as adjournments are concerned in those genuine cases. Like, take for example a case where some party is coming from somewhere to district court at Hon'ble. Something happens to that person on the way, and he gets delayed. He could not reach the court in time. He is supposed to go in the witness box. Let us imagine that he met with an accident. What is the court supposed to do? Court has no choice according to me to give time. This is how it happens in a court of law. Many times what happens is the court is flooded with 50 matters of the court. How many cases the court can take up in a particular session, either it is morning session or evening session? Maybe 5 or 10. What happens to 40 cases? Those 40 cases have to be adjourned. Now you have to blame it on somebody. Either the plaintiff has sought time or the defendant has sought time. As it is, even if both the lawyers are getting, half of the cases are not taken up because they wait till 1 o'clock and they are told that I don't have a time now, you please go. So therefore, adjournment is not so much of a problem. Adjournment, see, I am telling you, if judges are very smart, they will not simply sit down to adjournment. If they are in a position to take up the case, and those many number of cases, they will take it somehow. They will not retire and go into the chambers. If they have time, they will take up the matters and they will use that time. So adjournment, in my view, is not a major problem as far as disposal of the cases are concerned. The disposal of cases have a problem with two things. One is the number of cases, and second is about the competence of the cases. These are two causes. I am telling you, as a lawyer, if the judge wants to take up the matter, no lawyer can say no. He is bound to take up the case. If the judge, we have seen judges who have taken cases, we know that he is not going to adjourn the matter. The lawyers do not even request for an adjournment for such a case. But if the judge is not in a position to dispose of 50 matters, then what he is supposed to do? He knows that at 1 o'clock he is going to be told that the judge can take up only 5 matters, rest have to be adjourned. He is waiting for the whole morning session. So therefore, don't worry, the adjournment is not a problem for disposal of the case. That is my view. Thank you.
Could I ask a supplementary question to this?
Yes, yes, sure.
In terms of what happens on the board, is that there are multiple number of cases in a day. What is the logic when you can actually not address those number of cases?
By just listing it in the case.
Just listing it because it's a waste of everybody's time.
Yeah, I agree with you. I agree with you. But now there is the other side of it. I'll tell you. Supposing that if you go and do only 5 matters per day, okay, then if I have a case which is, let us say, filed recently, 1 year back, my next date will be given after 3 years. You understand? My next date will be after 3 years. Now, what I am going to speak about it, to say that my case is not being taken up by the court, it is not even listed before the court. And there are several steps which are taken during the course of a case. Like in a given scenario, like for example, there are stages of filing documents. It's a matter of 1 minute. It is filed and it is adjourned. So you can't say that you can't keep those matters on the court. You have to keep those matters on the court, where formal proceedings are to be taken up for the purpose of production of document, for the purpose of framing issues, so on and so forth. For many times documents are filed, pleadings are filed, affidavits are filed. So you have to keep those matters on the court. And otherwise it will be difficult. Like after 3 years, 4 years, people will start getting dates. So I don't think we can do much about it, and we need not do also. That is my view about that. Thank you.
Thank you, sir, for sharing your valuable knowledge and insights with us today. We also have among us President of South Goa Advocate Association and member of Board of Management of Devidas Pangam, Advocate Prasad Naik, and Vice President of Devidas Pangam, Advocate Preetham Morales, and I acknowledge their presence. I request Mr. Nitin Kurkar, President of Devidas Pangam, to present a token of appreciation to our guest. Thank you, sir. Every occasion is incomplete without an expression of gratitude. I invite the pillar of our strength and the source of our encouragement, our principal, Dr. Maria Kiretti Simois, to kindly deliver the word of thanks.
Thank you, Miriam. A very good afternoon to one and all who have gathered here today.
respected guest of the day, Senior Advocate Devidas Pangam, respected Advocate General of the state of Goa, the dynamic leader and visionary of Vikas Mandal, Shri Nitin Kukolikar, President of the Mandal, the first President of the Mandal, Advocate Pratham Marais, President of South Goa Advocates Association, Advocate Prasad Naik, faculty members and my dear students. Well, it gives me immense pleasure to offer my gratitude to our most knowledgeable guest. Well, it's not the first time that I personally have heard Senior Advocate deliver his talk today, as I have witnessed him steadfast and acting as a strong pillar, taking up all the cases before the High Court of Bombay and Goa. So, it has been really a pleasure to have you firstly amongst our midst, and secondly, you have very nicely demystified the language, in fact the technical language which is used in CPC. I'm sure that these technicalities are a little new to our students, but of course you have a long way to go. And this concept that Sir has taken today, the concept of jurisdiction, pecuniary jurisdiction, res judicata, res sub judice, will definitely play a key role in your practice in the future. So I'm sure that you have enjoyed the session and the questions that you have posed stated it all. So thank you for being with us today. And despite your busy schedule at the High Court, I know you have to rush back to the High Court. We won't take much of your time. Again, a great gratitude, a word of gratitude to you. Well, the super support offered by the President, Mr. Nitin Kukolikar, cannot be denied. It is because of him that we could organize such planned programs. It is because of his support, his unwavering support towards the institution and towards us for keeping us on our feet throughout has led us to this particular session. Thank you very much, sir, for always standing by us and for never saying no to any initiatives that have been taken by the college. Thank you, and most importantly for your presence here today. So I've come all the way from Panjim just to be amongst our mates today. Thank you. A very word of gratitude. Well, I also bow in acknowledgement to our coordinators, Ms. Shirley Souza and Ms. Akanksha Gelot. They are the ones who have meticulously planned and make sure it is meticulously implemented too. The minute Shirley came up with this proposal saying that I would like to invite Senior Advocate Mr. Pangam, so I said, why not? Please do it. She had many more on the list which I told her, not now. We will see it later. But I think you were the lucky one, sir, to have made it here today. So thank you for having organized this particular program today. And of course our students. It has been a tiring day, definitely yes, because there were a lot of NSS activities also which were planned. Despite of that, you all have made your presence felt in this auditorium. So I also bow in acknowledgement for this. And to all of you, especially Miriam, who rises up to the occasion at the 11th hour, cannot actually deny my gratitude to you as well. So thank you one and all. Have a lovely day ahead. Thank you.
Thank you. With this, we conclude our session, Insight on the Bare Act of CPC, how to demystify the technical language of the Bare Act. We hope that the knowledge shared today will be beneficial in understanding and navigating the complexities of CPC. Thank you all for your presence here today.
Yeah.